Good morning, this is your Kelso Report for Thursday, August 23rd, and I'm your host, Clark Kelso. I have just a couple of cases today. We begin with a habeas decision from the Ninth Circuit. As we all know by now, under the Anti-Terrorism and Effective Death Penalty Act, federal courts may not grant habeas relief unless the state court proceedings resulted in a decision that was either contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court, or was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Well, in Frost v. Van Boning, a Washington state trial court, misapplying state law, told defense counsel that he could argue to the jury either a duress defense or argue that the prosecution had not proven its case beyond a reasonable doubt, but that it could not argue both. The theory here was that the duress defense necessarily admitted all of the elements of the crime. As a result, defense counsel argued only duress and the jury convicted. The Washington Supreme Court affirmed the conviction, concluding that the trial court had erred in restricting defense counsel's closing argument, but the error was harmless. In his habeas petition, the petitioner argued that the Washington Supreme Court erred in not treating the trial court's restriction as a structural error requiring automatic reversal. The split panel of the Ninth Circuit disagreed, noting that the Supreme Court has found the existence of structural errors, that is, errors that affect the whole framework within which a trial proceeds, only in very limited circumstances, and that the court had never even addressed a claim such as the one presented in the habeas petition. Absent a clear holding from the Supreme Court that such an error was structural, the majority of the Ninth Circuit could not agree that the state court decision was an unreasonable application of clearly established federal law as determined by the Supreme Court. So the majority conducted its own review of the record and found and agreed that the error was indeed reasonably determined to be harmless. A good example of how the limited standard of review under habeas restricts the relief that federal courts can offer. Next, we have a case involving the Indian Child Welfare Act. The child, a member of the Torres-Martinez Desert Cahuilla Indian tribe, and his mother, in Re Anthony T., appealed an order placing the child in foster care with an Indian family. They contended the placement was not within reasonable proximity to the child's home, as apparently required under the Indian Child Welfare Act. Congress had enacted the ICWA to respond to a crisis in which large numbers of Indian children were being removed from their families for placement in non-Indian homes. It was designed to protect the interests of Indian children and promote the stability and security of Indian tribes and families by establishing minimum federal standards for the removal of Indian children from their families by state courts and the placement of such children in foster or adoptive homes. An Indian child in foster care must be placed in, quote, the least restrictive setting that most approximates a family within reasonable proximity to his or her home, taking into account any special needs of the child, close quote. In the absence of good cause to the contrary, the preferred placement order for an Indian child is with a member of the child's extended family, a foster home approved by the Indian child's tribe, an Indian foster home, or an institution for children approved by an Indian tribe or operated by an Indian organization. Well, the issue before the 4th District was whether being within reasonable proximity to his or her home was merely one of many factors to be considered, or was an independent requirement. Giving the statute a plain meaning interpretation, the court noted that the reasonable proximity criteria was placed alone in its own sentence, and that sentence used the word shall, which usually indicates a mandatory duty or requirement as opposed to a factor. Given that reading, the court held that the court may not select a placement for an Indian child unless that placement is within reasonable proximity to the child's home, where proximate means very near. Substantial restriction on where placements can be made. The appellate court reversed the Superior Court's placement order and remanded for reconsideration. That's it for today's Kelso Report. Have a great day in the law.